So, good morning. We are live on YouTube. It is, I shouldn't give you the date. Oh, Wednesday, April 28th, 2021. One of us was having some trouble, as you can see, getting ready this morning and still hasn't tied his tie. So that's why we're a little bit late. We apologize. There's nothing nefarious going on. We're taking up again H 183, and I will just state for the record, nobody was intending to kill the bill. Nobody was talking about getting rid of the bill. What people were talking about is how to define consent. And I will say again that when we took this up last week, we had already, Peggy and I and Michelle had already scheduled this hearing this morning. So if we had intended to kill the bill last week, we would not have scheduled this hearing. We are fortunate that we have a redraft that Michelle Childs has for alternative language to the consent sections 1, 2, and I think 3 of the bill. And so, Michelle, I'd like to start off with walking through those sections. I believe later on, Rebecca Turner will have a suggestion on section 3. We'll get to there when we get there. So thanks, Michelle.
Sure. So Peggy has put this up and it's on the website, but can everybody see that?
Yeah.
Okay. So this is just an excerpt. I didn't draft out the whole amendment because you haven't decided what to do about some of the other sections yet. So I just focused on the consent.
Right.
So section 1, so you see in subdivision 3 and 3251, your definition in current law for consent means words or actions by a person indicating a voluntary agreement to engage in a sexual act. And that would change to consent means the affirmative, unambiguous, and voluntary agreement to engage in a sexual act. And sexual act is defined in that section. Or conduct defined under section 2601 because the 3254 applies to lewd and lascivious conduct. So we want to make it clear that that's included in there as well, which can be revoked at any time. And so this is basically bringing in some of the language that you looked at in Oklahoma and bringing that into this definition. And then that's coupled with going to section 3254 on the consent language. Is that
Yep.
I'm sorry.
Before we go to the next, I just want to mention that what this does, and correct me if I'm wrong, is describe what consent is, not what it's not, which is what the House version did, and a lot of us were having trouble with that. I know you can't speak to that, but from my perspective, this defines what consent means.
I think they both define what consent is because I think, the existing definition, all they did was add the word knowing. So in this definition. And so I would say the existing definition plus the House version and this version, are saying what is consent. I think the issue around what isn't consent is where you were troubled more with 3054. And
okay, you're right.
And so I think so here is that we've added the new language there where it talks about that for prosecution under the sexual assault chapter or for L&L, consent shall be considered based on the totality of the circumstances.
Sorry, Michelle, when you're done, can I ask a question?
Sure. And so on subdivision 1, I just went back to the existing language. I think the new language that was in there in the House passed version was just kind of a rephrasing of that same language, but just rephrased to kind of more closely follow the federal language. I just reverted back because it seemed to be more confusing for folks. And so then division 2. is from federal law that I put in. It was in part of the House passed version. I don't think, again, it was something that y'all seem to struggle with, and I think it's just a given. An expression of lack of consent through words of conduct means there's no consent. I think it's kind of a given. And then I left the remaining subdivisions in there because that did not seem to be as concerning to, and so it was more around the issue of the 1 and 2 is what I was hearing from you. And then you wanted to put in the statement around considering the totality of the circumstances. And I think it's appropriate in here in this 32.4 than in but people may, I think, have different views on that. So it'll be interesting to hear from the witnesses about the cons that they see with regard to whether it should be in the definition or in 3250. Those are the two changes on that. I also, if once you get to talking about the rest of the bill, I didn't draft it into an amendment because I wasn't sure where everything's going with this amendment just yet. And but I do have that language from Honing that Senator White passed on to me about a tweak to the Intercollegiate Council. But since you guys haven't decided whether the council is going to be a part of this bill or not, I can just bring up Wendy's language and you can look at it. It's just a tweak to the duties of the council.
Right. Well, I think if we get the consent down to what we can agree on, then I think the rest of the bill will rather quickly move forward.
Right. And section 2, I didn't make any changes to section 2 because, again, that one is more kind of the elements of the crime. And again, I haven't really heard much concern from anybody on the committee.
Right.
Section 2.
So I have a question.
Senator Nick.
I'm wondering with regard to the L&L, how does that fall into section 1? Michelle, you mentioned that, and I'm just wondering, what does that mean in terms of consenting to L&L? I mean, isn't it L&L if a person standing on the street and exposes themselves to you? I mean, what is that changing in terms of?
No, but if you look at section 3254 and the current law,
Yep.
So that language currently is talking about consent, and it's within the sexual assault chapter, but you'll also sweep it in for the crime of L&L. So we're not broadening this idea of consent with regard to L&L. And L&L can be, as you know, it's where it says any, open or gross lewdness, or and there's always the question, well, what does that mean? But it's all been developed over years through case law. And I think probably some of the practitioners from the Defender General's office and the prosecutors can talk to you more about how that might play into this. But the definition of sexual act is very specific. And I don't have my statutes directory up, but it involves essentially like genital to genital contact, mouth to genital contact, things like that. Whereas L&L would encompass sexual conduct that doesn't quite rise to that level. So it could be, fondling the breasts or touching genitals or things like that, that doesn't fit within the sexual act definition. But it's already in current law here that the consent provisions in 3254 apply not just to sexual assault, but also to L&L. So this is just bringing some clarity into the definition section that it applies because it's already applying in 3254.
Sounds like a mess in terms of L&L, in terms of, is it somebody exposing themselves to you, not touching you in any way? Is that type of L&L, is that included here?
To engage, well, it's, You know what, let me take a look at it. I'll go back and look at it. I don't think it's changing anything with regard to current law. And I don't think it's applying in those cases that you're talking about, of like kind of the exposure to a stranger or something like that. I think it's aimed at the other ones, but let me circle back on that one. Okay.
thank you. Yes.
Thank you.
Mr. Chair.
Yes, Senator Baruth.
So I just wanted to say this Oklahoma language, I think is excellent. And my reason for that is the three words affirmative, unambiguous, and voluntary. So we had voluntary already, but especially unambiguous. I think that's getting to the heart of the matter, which is if there is any lack of clarity, if there's any doubt about the person's ability to consent, then the act can't go forward. And if it does, it's subject to this provision. So not only is there a yes and it's voluntary, but it's clear between the parties. And I think, to go back to what the chair said originally, my problem with the first draft was that, as he said, it was articulating throughout what consent was not. And that work was very important, and it was half of the equation, but it kept pointing me back to the need to update the actual consent language, the affirmative statement of what consent is. And I think this does that in a very efficient way. So that works really well. And Michelle's other changes, including getting rid of the line on the next page. Michelle, if you could just scroll down. Yeah, number
Right
2. Yep. I see what that line is trying to do, but I don't think it's necessary, and I think it's cleaner without it. I would note, Michelle, you didn't renumber yet, but I assume you'll do that.
No, I just wanted to, this is not drafted the way obviously it would look, because you wouldn't have an underline and a strike. I just wanted to show you what was there in the House proposal.
Got it.
No, it's easier for us to understand the way you've drafted it. And obviously, we'll change when and if we present this as an amendment.
Yeah, so that's my comment.
Appreciate that. Any other comments from the committee? Could we take that down so we can see everybody? Thank you. So we have a number of folks here. I guess I'm going to first go to David Scher, the Assistant Attorney General. David, good morning.
Good morning. Thank you, Senator. Thank you, committee. For the record, David Scher with the Attorney General's office. I appreciate the work the committee is doing on this, thinking seriously about these issues. They're very challenging issues, and we've been thinking a lot about how to make this work on our side as well in the office. As I mentioned last time we met on the issue, our office is very concerned about rapid changes to the consent definition, which is that's the fundamental piece. In a lot of cases proceed under a theory of non-consent. And so that definition, and they don't utilize other aspects of what is in section B. And so that section is very important. And it may be that the proposal you're looking at today is exactly the right way to move forward. But before we feel comfortable saying that, we would need to do a lot more research around how this has operated in fact. I believe this is the model from Oklahoma. Somebody else can correct me if I misstated where that's from. But we would want to make sure that we understand exactly how cases are proceeding under this in the jurisdiction that it's modeled after. And we have not had the opportunity to do that work. And it would be a detailed look at how specific cases are proceeding, what issues have arisen, what challenges have arisen to a prosecution. And it is also going to require a serious look around how it will fit into our statutes, which are not going to be exactly, the other relevant statutory sections are not going to be exactly the same as what is in the jurisdiction that this is taken from. So we do have a lot of concern around a major change to the consent definition without doing a lot more work on that. And that's work we're happy to do, but we do need a bit more time to dig in to what the effects might really be. So that's my primary comment today, or at this time. I know the discussion is going to continue, and I'm happy to jump in on some other specific issues. Just a couple other things I wanted to note was the addition of the totality of the circumstances language in section 3. We would really want to explore more before we could support that, what effect that's going to have. It's our read of the current statute that is effectively what's there already. You couldn't bring a case without having done an investigation that takes into account all of the circumstances that might be relevant to proving the charge and to bringing a prima facie case and ultimately proving it in front of the jury. And so we're not exactly sure what that is adding, what meaning that's adding, and whether or not that may restrict the ability to prosecute cases that could be prosecuted now. Again, we don't know that for sure, but that's part of the concern, is that these changes are they're not additions, they are changes to the most base, in the sense that they are changes to the most basic prosecutions, the straightforward, and I don't want nothing straightforward in this world, but the sort of basic no consent sexual assault cases. And our criminal division is very concerned with changes that may impact those and potentially have unforeseen complications. One thought that I had in terms of just looking at these changes, we do think that section 2 is a section that has raised relatively few concerns on the committees. We certainly have supported that throughout. We also think that is really getting at the heart of the impetus behind the bill as it originally came forward regarding impairment issues and making sure that those are prosecutable. And so it may be the case that is a piece we can focus on as something to move forward if the other two, sections 1 and 3 remain challenging to work through. But that's, we supported the version as came out of the House too, to be clear on that. But just a sort of thinking out loud about ways forward here. But just wanted to register our concern primarily with a dramatic change to the consent definition without considerably more work to understand both what's happening in the jurisdiction where it came from and how it might interact with our own statutes. And happy to take questions or be present for the conversation.
Well, I'll just make one comment. It's very dangerous to talk out loud in this environment. We've seen what's happened when you do think out loud, I should say. I appreciate the comments. Obviously, the committee was uncomfortable with several of at least section 1 and section 3 of the House version of the bill, and was seeking some kind of resolution. And that resolution, to me, relied on the thinking about the totality of the circumstances. And I think what Senator Ruth pointed out regarding the unambiguous consent means, and I think that's, so for us, those changes, at least in section 3 and in section 1, I hear what you're saying, but I'm inclined to support them. I'd like to hear from Nick. Are there any questions of David? David, thank you very much for your comments here.
Thank you, Senator.
We're as you know, things are winding down this week in the Senate anyway. There might, if we pass this version, there'll probably be a committee conference. And we can certainly have a discussion during that process. Rory Siebold, representing the Office of State's Attorneys.
Good morning, everyone. And for the record,
Morning.
State's Attorney Roy Tebow, Washington County. So I'll start with, the first comment being it's always uncomfortable if you have two sets of prosecutors in the state coming to potentially different conclusions. I do want to share that yesterday I had the opportunity and I sit on the executive committee of state's attorneys, and we had a regular meeting yesterday to talk about some budget things and other exciting stuff. During that, yeah, I'm sure I know some of the senators are also immersed in that work as well, but I had the opportunity to really go, not so much a deep dive, but talk about the latest Senate proposal and analysis of H-183. And in particular, State's Attorney Marthage provided some good feedback, as did State's Attorney Hughes on this. And the consensus was that the totality standard, as David indicated, is already de facto how we assess things. And that led me to do a little bit more research. And I shared with some of the other stakeholders that while not embedded in statute, the state of New York in their jury instructions for rape in the third degree does include language about considering all circumstances. So effectively, they've adopted a totality of the circumstance approach in their jury instructions that are provided to individuals. From my standpoint, as a practitioner, trying to take off to the extent I can a prosecutor's hat and looking at fairness, I think the Oklahoma definition that Senator Ruth brought to our attention does clarify what the term consent means. I think the corresponding balance to that maybe addresses some of the concerns raised by Senator Benning previously is to ensure that we do have a mechanism to ensure that we're considering the totality with limitations for rape shield or other things that can't be considered. So in the sense of trying to balance or find the right definition, I believe the Senate proposal here does do so in ensuring that one, a clear definition is also met with a clear expectation of what that evidence can be in a trial setting. It's important to note as well that any evidence considered in court also has to be subject to the rules of evidence and other trial considerations. So including the totality of the circumstances is already how we practice. And I would note, of course, that when a defendant needs to present evidence that is constitutionally required as part of his or her defense, they're entitled to do so. And that often does include a lot of attendant circumstances and past history. To answer Senator Nicka's question about L&L, Vermont has a somewhat unique construct when it comes to dealing with that type of behavior. L&L is a common law, a public disorder, and again, historically would be more of the masturbation in public or exposure in public with some sort of sexual intent or gratification involved. We've morphed that over time through case law and practice to really cover what other states would call sexual battery, or the federal statutes consider aggravated sexual contact. We don't have such a distinction there. So sometimes there are these awkward moments where you're looking at this public disorder versus a crime committed against a person. But that being said, Michelle's analysis is correct. The same consent definition already applies to existing L&L. So someone can expose themselves in public, and that can be, or in front of another person, and that can be consensual conduct that they are entertained by or want to have happen. That conduct can also be without consent. Most frequently encountered, of course, though, our L&L statutes are mostly used for sexual contact. So things that don't involve penetration, but involve, as Michelle mentioned, groping, fondling, grabbing, different things that have a sexual impetus or element to them, but don't involve the same degree of body violation that a sexual act, as their definition would include. So I hope that clarifies that, and the existing consent statute and definition does apply to those type of offenses. So on balance, again, recognizing that there is some hesitation on the part of the Attorney General's office, I think that hesitation is not as evenly shared among states' attorneys. And ultimately, I think our belief is that improving and modernizing the statutory language is appropriate, and this is an appropriate juncture. The fact that we do have other states to look to and that we're not creating a new definition out of thin air is helpful. And here I believe Oklahoma precedent, coupled with looking to how other states have dealt with the evidentiary standard of a totality of the circumstances, and Vermont's own dealing with totality of the circumstances, mean that we're not treading into dangerous or uncharted legal territory. Rather, we're doing what we expect practitioners and courts to do, which is interpret the law based upon the plain meaning of the words involved, and also secondary or persuasive sources that can come from either other areas of Vermont law or the states upon which we base it. So from that standpoint, the Department of State's Attorneys and Sheriffs continues its support for H-183, and we believe here that the Senate's modifications or proposed amendment to H-183 is consistent with the overall goals of the bill.
Thank you very much, and I thank you for bringing it to the executive committee. I know that State Attorney Marthage and Hughes have been working in the field for a long time and have a lot of experience in this. Not to suggest other state attorneys don't. So any questions for Rory? Thank you very much. Sarah Robinson, and then we'll hear from Rebecca Turner, who has a proposal, and we can all talk about that afterwards. Sarah, thank you so much for I want to also thank you for your reasoned approach. I'm sure it's very difficult to listen to this conversation as an advocate for women who have suffered through, well, women and some men who suffered through the rape and other issues, and that you've been steadfast in your cooperation with this committee. I appreciate that.
Well, thank you. I appreciate that. And I also want to just thank the committee for your continued consideration of this bill. We always expect that the Senate will take a look at their own fresh look at any bill that comes over from the House, just like we expect the House to do the same of the Senate. So we're thankful for your continued conversation. And I know that we share the same goal in knowing that, you know, changing the consent law is a major policy change. And so we want to make sure that we get it right. I know everyone shares that goal. So specifically on the redraft on section 1, the new definition of consent based on the Oklahoma language, we think that there are a lot of strong elements in this definition. Notably the inclusion of the unambiguous language, as Senator Baruth highlighted, as well as the language about consent being able to be revoked at any time. I think that's a really important element that has been added. And on the face of it, we think that this could really be a marked improvement over the current definition. Certainly, we want to understand any potential implications of the change. I did reach out to our peer organization in Oklahoma, and I have some, but not a comprehensive understanding about how that language has played out there in case law. So that would just be a minor word of caution. But again, I think that we're generally supportive of and feel like there's some strong elements to that definition. On the changes to section 3, we do have some concerns about the totality of the circumstances language. And I think that when it comes down to it, the primary question is specifically, what sorts of circumstances does this language invite to be considered? And while we acknowledge that it's subject to the rape shield law and the other subsections of section 3, the truth is that our rape shield law is not a perfect shield. And we're somewhat concerned that including this language will mean that justice system actors, from law enforcement officers determining whether they have probable cause to prosecutors making charging decisions, all the way to juries, will not only consider whether the acts in question violated the definition of consent, but what other circumstances might explain the behavior. And as we've discussed, before, there are these persistent myths about sexual violence itself, about false reporting, and we do have some concern that the language perhaps provides an opportunity for these biases to enter into the process. We did an initial search of other statutes across the country and haven't found any other consent or sexual assault statutes that include the language totality of the circumstances. I did hear State's Attorney Thibault discussed that there is a reference to all circumstances in New York jury instructions, but we have a little bit of concern with putting this directly into statute, where throughout the entire process, not just the jury process, but at the law enforcement stage, at the prosecutorial stage, other circumstances will perhaps be invited to be considered. So that's our feeling on the change to section 3 around that particular language, and the other changes to section 3 we're supportive of and do believe that it adds additional clarity.
Thank you. Questions for Sarah? Again, thank you, Sarah. Oh,
Thank you.
Senator White has a question for Sarah.
Thanks. And
Go
I'm
ahead.
not sure that this is a question for Sarah, but so there's been no disagreement on the committee at all around the section that, and I don't have it in front of me right now, around the where consent simply can't be given if somebody is incapable for because they're passed out or whatever. So
That's section 2. I
okay.
believe.
So my question is, since there's seems to be a lot of concern around what consent is and what consent isn't, could we pass this with just that section 2, second part, and leave this part to more work like you suggested over the summer, but pass it with that other part in there. I'm just trying to figure out if we can do something, because I think that other part is really important to get done now.
Well, you could pass section 1 and 2 and not change section 3.
You could also, 2 could stand alone. I think, Jeanette, is your question whether or not if you just didn't have a section 1 and 3 because of disagreement, 2, you could just have 2. That's dependent on the changes in 1 and 3.
That's my question.
Would just have 2?
I'd be uncomfortable without changing 1, just from my perspective.
You'd be okay without changing.
Well, I would just leave it out completely.
Well, then you okay.
Strike it from the House bill.
All right.
That's what I meant.
Jeanette, strike which from the House bill?
Well, I don't have it right in front of me now, but the part that talks about what consent isn't,
Right.
I think
take
Yeah.
that out and then just leave the part. So we're not addressing that at all now. And over the summer, Sarah's group can work on a better definition, but leave in the part that there can be no consent when someone is passed out or unconscious, or that's what I'm getting at.
so. You would leave the definitions the same as current law.
As current law, not as passed by
32
the House.
and 3254 that fleshes out consent as current law, and you would only change section 2 with regard to the impairment.
Yes, that's what I was, thank you. That is what I was trying to get at, is that if we could get that in there and pass that, it seems to me that that is a really important thing to get done now.
Okay, well, that adds to the complexity. Personally, I'm supportive of section 1. I'm a little, in terms of section 3, I probably could live with current law, but
I just
Senator
was
Bruce?
afraid of,
yeah.
Sarah
Senator Bruce?
had,
I'll just echo what you just said, Mr. Chair. The section 3, totality of the circumstances, I'm of 2 minds about that. Section 1, I like very much the way it's rewritten, and I like the way it balances with section 2. So I could vote for all 3. I would have a harder time voting just for 2, as Senator White suggested, because I do think it kept leading us back to the need to change the original definition of consent, and I like where that stands now. So I suppose my druthers would be to move forward with 1, 2, and 3. But if we're not going to move one of the sections, I would think for me it would be 3 rather than 1.
I guess that brings me up because I'm in the opposite camp. I think section 3's inclusion of the totality of circumstances relieves the concern that I was expressing previously. So I'm hoping that we can move all three.
Well, then we're in agreement.
Could I ask
Senator
Sarah,
White?
could I ask Sarah a question about, to elaborate just a little bit on what you meant about the, including the totality of the circumstances and how that might be actually not a positive thing?
Well, I think that the essential question is what other circumstances ought to be considered.
Mhm.
And, you know, we can see the circumstances that are prohibited from consideration in the rape shield law and the other subsections in section 3. But I think it just invites the question, so what other circumstances ought to be considered? And I think unless we have a good answer for that question, I think we'd be very concerned about that language.
Can you give me an example?
Honestly, I have been struggling to find one, which is why I'm concerned about it. Because when I think about the sorts of circumstances that might be considered, they often rely on, you know, the fact that these cases are very complicated. They often involve people with, they might involve people with long histories with each other. They might involve two people who may both be imperfect in their own way. And I am concerned that it will allow in some bias that tends to be present in the justice system, frankly, against victims of sexual assault, into the consideration of whether there was in fact a violation of consent.
Mhm. So you could take, if somebody had a long-standing relationship, but this, it had gotten out of hand, that could be taken in as part of the totality of the circumstances when it shouldn't be in this instance.
So some of that previous sexual relationship is highlighted in the rape shield statute. But I would just say that, again, I don't think that that is a perfect shield. And I think that there are ways that there can be victim blaming that still enters into the process around choices that victims may make, that I'm concerned the totality of the circumstances may invite in further consideration of those elements.
Mhm.
Thank you.
Mhm.
Michelle, can I ask a question? Current law regarding consent, which is over 40 years old, am I correct? Is that consent means words or actions by a person indicating a voluntary agreement to engage in a sexual act. Is that correct?
Mhm.
That's current law, hasn't been updated for 40 years. And so we would be leaving that alone if we didn't change section 1. So and I thought that was one of the most important things that we should be doing, was changing that. So if we were to change that, go with the section 2 as the House passed it, and not do section 3, what would happen then? Would that be
If you
would it be
didn't do,
confusing for the trial courts to not have that section regarding trial court instructions? That would go back to the current law.
if you just had current law for 3, and then what would you do with 1? You would
Change
have
it the way it's been proposed in this draft. The current draft.
I think section 3 brings in, I think, some clarity around some other aspects there. I mean, you don't have to have 3. It's not, you don't have to have updates to 3, but I do think that there's some language in there that is helpful, that's outside of the issue of totality of the circumstances. But no, they're not dependent on one another, I wouldn't say.
So but the other alternative is just in section 3 to say consent shall be considered based on the subject and on and subject to the following, and take out totality of the circumstances. You could do that, correct?
Yeah, you can take out that and just go to the current law as the intro and then change the subdivisions like in this proposal. Yes.
Yeah. Okay. Thank you. That leads me into, are there any other questions there? Rebecca Turner has a suggestion in section 1, I believe.
Good morning,
Good morning.
everyone. For the record, Attorney Rebecca Turner from the Defender General's Office. And yes, thank you for acknowledging the proposal that the Defender General's Office submitted. And in a nutshell, the proposal would suggest eliminating sections, all the sections in the bill except for section 1 relating to consent. And the proposal reflects what the Attorney Scher from the Attorney General's Office expressed earlier this morning, and that is that the Defender General's Office joins the prosecutors from the Attorney General's Office in our concern, their concern, we joined their concern that this current proposal, including the proposal submitted by Michelle Childs this morning to sections 1 and 3, constitutes a substantial change in current sexual assault jurisprudence, a substantial change that, as Attorney Scher already talked about, puts into an unknown how prosecutions will flush out even if this language is adopted. And given that I have been listening to the committee's discussions and concerns, including the need for recognizing the nuances and all of the subtleties of real life, and the importance of having a totality of the circumstances standard, which I also heard Attorney Thibault share today, that is the standard of our current law, and as well as the concerns for making more clear what is consent and tapping into the language from Oklahoma and the 3 added words there that has been included here. We think that the proposal, and again, let me pull up the proposal here, but the significant changes for this section 1 as compared to the draft currently before you. It continues to include the three words, and actually voluntary is current law in Vermont. So it really is taking on the 2 terms from the Oklahoma statute, affirmative and unambiguous, acknowledging that is the desire for more clarity on the consent front, but also incorporating the totality of the circumstances standard in this section again, because that seems to be where it naturally fits. You're defining what consent is. If we all understand current law is, but perhaps we need to make more clear that it is understood also in the context of the totality of the circumstances of a given case, then we bring it all together and provide that clarity that I understand is also needed. In terms of deleting, I want to explain the deletion of references to and I thought it was a typo, Michelle, but I understand it's not a typo, the reference to the lewd and lascivious conduct statute, and the addition of not just defining and including in consent sexual acts, but sexual conduct. Now that's a substantial change in current law, which is limited to sexual acts, not sexual conduct. And the sexual assault statute itself is only involved 3252, and that's covered in section 2. That only involves sexual acts. That's the issue at hand, not sexual conduct. So to add an entirely new phrase of consent to include sexual conduct broadens this in ways, and again, I join the statements by Attorney Scher on this in terms of the unknown consequences of this. It certainly isn't even necessary for the sexual assault statute under 3252 because it's just not referenced sexual conduct. And There were questions earlier this morning by Senator Nitka in terms of, does the definition of lewd and lascivious behavior provide a model of clarity? And I just want to share with the committee, as an appellate defender and my other hat for job duties, as recently as October of 2020, this Vermont Supreme Court addressed a challenge on the vagueness, the constitutionality on void for vagueness grounds of the lewd and lascivious statute. And that came out in a decision in Ray AP 2020 VT 86. In there, the majority, there was a split court, and the majority of the justices found that in that particular case, it survived a constitutional challenge of void for vagueness. That's the lewd and lascivious definition. Justice Robinson took time to write a dissent to say that she would strike down the statute as unconstitutional. So I would actually say that by adding that link, not only is it not necessary, the sexual conduct definition to lewd and lascivious behavior, you're now opening up the door to further litigation and challenges. So that brings me back to why the proposal from the Defender General's office dropped that reference to 2601, dropped reference to conduct, kept it to the original language of sexual act. And then also included the additional new language, which is that consent can be revoked at any time. I think that actually is already the reflection of current law, as is the inclusion of the totality of the circumstances. And I can pause here to take questions, but I wanted to briefly talk about Section 2 because I'm hearing that there is possible interest in going forward with Section 2. But I want to highlight that I actually think that the proposed changes in Section 2 does also constitute a considerable change in current law that hasn't had a chance to be perhaps considered thoroughly. And quickly, I'll just highlight that here. There is a suggestion to delete the word compel in that language, as well as to drop mens rea requirements relating to the sleeping or unconscious person situation, as well as in the latter section relating to substantial impairment. Again, there's an injection of dropping a mens rea requirement that hasn't been done before, and as well as dropping a compel. So it actually provides some significant substantial departures from current law on the definition of the essential elements of sexual assault. So I would, if this committee feels the need to move forward on some changes and updating the consent aspect to sexual consent, suggest it limit itself to Section 1 as proposed by our office.
I think I understand completely, and I can understand why the Defender General's office would oppose changes to the consent laws. But I also understand why the advocates for the bill, including the co-sponsors who've been very vocal about our, how shall I delicately put it, our being Senate Judiciary's deliberations notwithstanding. I understand, why they are so passionate about this, and I understand why a 40-year-old term of consent needs to be addressed and changed. So I'm going to make a suggestion that we adopt Section 1, Section 2, Section 1 as seen in the Michelle Childs draft today, Section 2 as passed by the other body, Section 3 taking out the new language that consent should be considered based on the totality of circumstances, and do the changes that are suggested in 1, 2, 3, 4, 5, 6. And I believe going over to the second page, all of the changes that Michelle made. Further suggest that we strike Section 5. We keep the Section 4, which is data collection.
Mr. Chair,
But
I'm wondering if we don't have the bill up in front of us.
oh, okay.
So it's a little hard.
All right.
If we're gonna
Um,
leave these, if we stay within 1 and 3.
Well, I'm making a
comfortable.
suggestion that we.
Yeah.
I think it'll be clear that section 4 has to do with data collection,
Yeah,
which I'm fine with. I think that's important. Section 5, I would suggest we strike, which is the council. Section 6, I would suggest we strike, which is a repeal of the council. So if you didn't do 5, you can't do 6. And I suggest we strike all of the budget items or the appropriations in section 7, since we've already placed the nurse, forensic nurse examiner, $40,000 in this year's budget on the Senate side.
Can I ask you a question?
Before you do that, Senator Bruce next.
Oh.
I
Yes.
I will back up that proposal entirely. It matches with where I was going to go. The only thing I will say is that I don't like, and I assume this is part of your suggestion, Mr. Chair, I don't like the Defender General's change to the new consent definition. The proposal to add totality of the circumstances there, I think it muddies the waters there considerably. So as Michelle drafted it, and I assume that's what you were referencing.
Yeah.
I would support your proposal.
Thank you. All right, Senator White.
I have to look at Michelle's language again here because I got really confused when you were suggesting which to drop and which to add. And
Okay, well, maybe Michelle could.
You want me to pop it up?
Yeah, please.
I've got it here in front of me now, but okay.
I would prefer to have it popped up on the screen.
Okay.
There we go.
Well, we're popping it up, but remember, I can't see all of you, so scream or raise your hand, whatever you need to do in order to get my attention.
Yep.
Okay, so my suggestion is, my proposal is that we adopt the version of consent that we see right there in 3.
So
Now go down to number 2, and where we have trial procedure consent, that we drop if a prosecution for a crime defined in this chapter, we drop the consent shall be considered based on the totality of the circumstances subject to the following. I get that we still keep the chapter subject to the following, and then we do all the yellow language that's in section 3, the rest of that yellow language. Is that clear?
Well, it's clear, but I'm having trouble
Well,
with
let's get clear what the proposal is, and then from there we can debate whether or not to keep. I'm trying to get us down to where our differences are smaller. So the real argument would be in the trial procedure, the words totality of the circumstances, where I would be different from what was presented by Michelle this morning.
and
Given that it's already part of the process, several have argued, and so that's my suggestion.
I think Jeanette had a question right there. Did you?
well, I had a couple questions. The totality of the circumstances, that was Sarah had real issues with that around what might.
Right,
be
that's
brought
why
up.
I'm suggesting taking it out.
I thought you said.
Because no, I suggested taking out the term totality of the circumstances because of Sarah's concern.
Oh,
And because of Rory's testimony, I believe that it's already
It's already.
considered
Okay.
in the case. The question was whether it needed to be stated and what by stating it in statute would it impact. So
Okay.
that's what I was going by, and I'm fine with. I want to really emphasize to Sarah and others that might be listening, when I said strike section 7, which is the appropriations, your 3 members of Senate Judiciary on the Senate Appropriations Committee were able to have that section regarding the nurse examiners put into our version, the Senate version of the budget. So because we were uncertain of where this would go. We also felt that it was important to make sure that it got funded no matter what happens to this bill.
Thank you
Senator
for that,
Sears, I just drafted this up while you guys were chatting. Do you want me to pop
Yep.
it up? How it would look,
Sure.
what
Yeah.
you're proposing?
Yeah, that would probably be helpful. Yeah.
So
Wow,
Could
you're
I-
good at that.
could I ask a couple
Can be
of,
after all this time.
Could you wait till Michelle pops up the redraft?
yeah, well, it isn't
Senator
on that
White?
part, but yep. I'll
Oh,
wait.
okay, go ahead. What's your question?
Well, I know that we all liked the term unambiguous, except that both the Defender General and the Attorney General's office didn't like that because they thought it, if I remember right, because they thought it was a major change to it. And then I also had the question about that Rebecca brought up about the including the lewd and lascivious in here, because we're talking about sexual conduct instead of sexual acts, and that seemed to be an issue. So I had those two questions.
Right?
Mr. Chair.
So, yep,
Oh.
Senator Baruth, go ahead.
I just wanted to speak to, and I take the point, certainly the AG's office is always thinking about current prosecutions and not wanting to create difficulties there, and also future prosecutions. And I think we should be respectful of case law. On the other hand, case law springs up around law, and we write the law. And I think the overriding concern here for me is that this consent language needs updating. This seems to me a really solid definition, which we worked to find. So what I understood the AG's office to be saying was that they would prefer to have more time to investigate it. I didn't hear them opposing it so much as raising cautions. I think we have been cautious. And this also has another road to travel back to the House, where they will again take testimony. And in the meanwhile, it may be that the AG's office can do some of the work that David Scher talked about. So I take Jeanette's point, and it's a valid concern. I just, on balance, I still favor changing out that definition.
I like affirmative and voluntary, but almost everything is ambiguous. There's very little in this world that's unambiguous. So I think that that's a challenging term, but
Any other comments on that section from the committee? Let's go to section 2.
Dick, you're calling it section 2, but I've got section 3 on the screen here. And I want to talk about section 3 at whatever point.
Well, section 2, Michelle is going over what the new draft would look like, Joe. So section 2 is where we define sexual assault.
So these are the elements.
And this is the same as the House passed.
This is the same, right? So you have the aspect, so it's no person shall engage in sexual act with a person without their consent, by threats or coercion, by placing them in fear that they'll suffer imminent bodily injury, or when the person knows or reasonably should know the other person is asleep, unconscious, or otherwise aware that the sexual act is occurring. And I just want to address one thing is I think I have a disagreement with Attorney Turner on, I think she said it eliminates the mens rea. And I think what she was referring to is subdivision A4. I view that as a reckless standard on the knows or reasonably should have known. And again, that's language that we use currently in the sexual abuse of a vulnerable adult statute, as well as the stalking statute. I think she views it as strict liability. And I'm not sure, I don't think we've talked a ton about that. So I'm not sure about the AG and the state's attorney's office, if they want to weigh in on that. But I just wanted to clarify that I have a different view of that, and I do not see that eliminating mens rea. Subsection B, this is the section when we talked about, we have language that is similar to what was in Minnesota in the case where around voluntary versus involuntary intoxication. We don't have the definition of mentally incapacitated like they did, but what this is doing is just rephrasing subdivision B to be now 1. So if a person administers alcohol or a drug or intoxicant to someone and they don't know about it, and then that person engages in sexual assault, in sexual conduct with that person, that's B1. But B2 clarifies that no person shall engage in a sexual act with another person when the other person's incapable of consenting. And remember, you have the definition of incapable of consenting due to substantial impairment by alcohol, drugs, or other intoxicants. And that condition is known or reasonably should be known by the person. And so I think that was the language that Senator White was interested in, definitely preserving as part of section 2. And so those are the changes to 2.
Is there, it's Alice, is there a definition of substantial impairment someplace else in the law?
No, but it is used. If you look at B1 and the language that, it's not substantial impairment, but you'll see the struck language. You'll see no person shall engage in a sexual act with another person and impair substantially the ability of the other person to appraise or control conduct. So I would consider that to be like substantial impairment. That substantial requirement is taken out now of B1 and
Right.
in B2. And that's because the House was looking at it like if you drug somebody, you drop some GHB or whatever it is and someone's drinking a bar and they don't know about it, and then you go home and engage in a sexual act with them, it doesn't really matter the degree to which they have become impaired by that drugging them. It's still a sexual assault, but the substantial impairment is a part of subdivision 2. So there is a distinction there between those two.
Kind of like this substantial, as it says that the other person, well, I guess maybe it's the same thing, the other person to appraise or control conduct. I'm sure that's referring to their own. Oh, okay. Okay, thanks. Persons, it seems substantial. I think that people will question what is substantial impairment.
Michelle,
I'm sorry. Yep.
am I right that, and this maybe speaks to the House's deliberations or maybe in Minnesota or wherever, but is that getting at the objection that if it just said impairment, then a single drink might invoke this provision or something like that?
Right. Yeah. Is that, you have somebody has a couple of glasses of wine and they may be a little impaired, but they are not necessarily incapable of consenting to the sexual act.
Mm-hmm.
So the substantial was added by the House to make it clear that, couple substantial impairment and incapable of consenting, due to, they're incapable of consenting due to substantial impairment. And then again, looking at all of the evidence, you met the person at the bar. Was that, did the bartender cut off that person and stop serving the person because they appeared substantially impaired? And then you go home with that person and that person is, vomiting and passes out or falls asleep on the couch.
And you recounted for us a recent incident. I forget where it was, but where the woman was rejected at the bar, and then someone offered to take them to a party, and she passed out upon arriving at the apartment. So I actually like substantial impairment. I think that avoids some, critique of there's a general critique from the other side of language like this or laws like this, that it will make it too easy to prosecute people. And I think this strikes a balance. So I support this house language, I guess.
Yes, I would just like to say it really seems to clear up the substantial impairment where it says to appraise or control conduct. In other words, the ability to do that is gone.
Well, Alice, if you look at incapable of consenting, because that's a phrase that we use now in B2, which is that specific language is not used in the current B, is that you have that, I would say, encompassed in your definition of incapable of consenting. So incapable of understanding the nature of the conduct at issue. Physically incapable of resisting or declining participation or communicating unwillingness, or lacking the mental ability to communicate a decision. And so I think that if you added that, if you added this ability, the other person to appraise or control conduct, I think it's,
Right.
I just think it's already, I think it's already covered in this incapable of consenting, which the current law doesn't already have.
Okay. Okay.
Okay, can we move along?
Can I ask a question? Michelle,
Sure.
the words or conduct do not appear here. And I'm trying to figure out how the term consent as defined with the words or conduct and the absence of that here interplays. And I just,
You mean the sexual act versus L&L?
yeah, I take, if a woman exposes her breasts in a public place, I'm struggling with the way the consent language would bring that into the loop in my eyes, because 2601 would include, well, perhaps not the breasts, but certainly the genitals.
Right.
Um,
I know what you're saying, and I think the reason why that is and it doesn't have to be in here, but again, I think I disagree with Rebecca on the issue of that it's adding this new thing in the definition of consent, because what you have is 3254, which is kind of further detailing what constitutes consent, applies to 2601. And so, but if you're looking at this section 3252, we're just talking about sexual assault there. So I just brought up the reference to 2601 that's in 3254 and put it up here so it ties 3254 up with this, but 3252 is not addressing any of the L&L stuff. So it doesn't need to address conduct. Does that address your issue, or are you talking about conduct?
No, you're clearing it up for me. I'm trying to think this through very carefully. And this is a lot to consider in a very short period of time. I'm just trying to see the factual circumstances that I've run into over my lifetime, wondering how each of those things could come into play here. I'm still, frankly, Mr. Chair, a little bit concerned about dropping the language of the totality of the circumstances. I understand Sarah's thought, but Sarah came to us with no specific examples of why that would be problematic. On the flip side, State's Attorney Thibodeau and certainly Rebecca Turner have demonstrated we have many decades of case law that have incorporated that philosophy into the picture. And I'm struggling, I guess, to understand why we would feel the need to drop that provision in the absence of any specific problem being presented.
Yep. Right.
May I ask a question of
Oh,
Michelle?
sure. Yeah, please do.
So this is different, and I don't know if you want to follow up on Joe's comment first or not.
No,
I think it's just a comment. I mean,
Okay,
I don't think he was, I think he was
Okay.
expressing his support for totality of the
Yeah.
circumstances. And I'm
okay.
suggesting that he could amend the bill, amend my motion to keep that.
So my question is, how can you have consent to L and L? I mean, I don't get that at all. Consent is the affirmative, unambiguous, and voluntary agreement to engage in a sexual act or conduct. I mean, I give consent to engage in somebody bearing his self to me in the park. I mean, I don't understand that at all. Why
Well, I
that
think-
we would even put that?
it could be that, you know, somebody, let's say a couple is at North Beach. They're laying out on the beach and their bathing suits or whatever, and they start making out pretty intensely or whatever's going on there, that they could be charged with L&L. But there's consent there, but that could be a violation of L&L. I don't know that I'm necessarily the best person to give you scenarios. I'm sure the practitioners having, you know, different factual circumstances.
It doesn't make any sense to me that consent is, they could be charged with L&L, but
I think maybe
I don't get that.
State Attorney Thibault has a response to the question.
Oh, okay.
I hope.
Good morning
I hope
again.
it's a response to that question.
It is. So Senator White, I think you're, really hitting the nail on the head, which is we do have this odd friction where we do a lot with our L&L statute. And while Rebecca's correct in citing that it's not void for vagueness, this is probably something in a future session the legislature should look at, of differentiating sexual battery or non-consensual sexual contact from the public disorder. But that said, the legislature did take steps on this going back a few years ago in differentiating what's called prohibited conduct from L&L. So a few years ago, 13 VSA 2601A was implemented, which deals with a lewd act in a public setting. That really captures now the predominance of things of someone masturbating in public or doing something exhibitionist with a sexual element, not just being nude in public, but doing something sexualized in public as well. And that means de facto today, L&L as we know it, or lewd and lascivious conduct, is really, again, sort of analogous to sexual battery. To give some context for this, there's two parts. We always just have L&L, lewd and lascivious. Well, a lewd act is different than lascivious, and lascivious is an intent element, meaning that it has to be done for, well, I'll just read you the definitions we give to juries for this. Lewdness is defined as gross and wanton indecency in sexual relations, whereas lascivious means tending to excite lust. So you need to be doing something with an intention of exciting lust and then also engaging in some sort of indecency, not just indecency alone. So in that sense, to use Michelle's example, if you have a couple out in North End Beach or whatever, if they just sort of caught in the act, that's not necessarily for purposes of exciting lust of other, non-consensual observers of that activity. Rather, they're just sort of doing something lewd in public, and it's prohibited conduct, not L&L. Whereas it's different when someone's touching someone without their consent or permission to excite their lust. The weird construct we have under Vermont case law right now is the open and gross element of lewd and lascivious conduct requires there to be at least one person who's not consenting to that activity. Frequently, that one person is our actual victim or complaining witness, not some third party. So in that sense, we have literally some tortured case law that says the victim of an L&L is that non-consensual person. And here we're looking at the touching or act where the indecency is directed towards that person, hence why we have to apply a consent definition under existing law and under this layout.
It sounds like the committee and you have come up with a problem area in current Vermont law. I think the Sentencing Commission is the ideal group to look at this, and perhaps we could ask the Sentencing Commission to look at this issue that's been raised and come back to the legislature with a report next November 15th or something like
So
that.
may I ask for a
Can I just,
question?
can I just,
Oh, I'm
please,
sorry.
before you?
Yeah.
So I do think it should be looked at. I don't think it should hold up this bill. So we could do a section of this, just an added section of the bill to have the Sentencing Commission look at the issues surrounding lewd and lascivious behaviors that might come into this bill, come into the consent statute. They're already there, so I don't. Go ahead, Senator White.
Well, I'm still confused as to why we would add that in here, because if there wouldn't be consent in a lewd and lascivious.
Because if we take it, my understanding is if we took it out now, we would really mess up the situation in terms of prosecution. Am I missing something, Rory?
No, that's correct. We'd no longer have any kind of logical linkage back to a statutory consent definition for L&L.
In other words, it's not this bill that's making the problem, it's a pre-existing problem.
It's your pre-existing condition and we can't fix it in this bill. I think to try to fix it right now, I'm glad that both Senator Nitker and Senator White have raised the issue. I'm suggesting that the solution could lie with the Sentencing Commission making recommendations on this particular piece of, on this, in this bill as a section, a new section 5 or whatever. So, other questions on?
I'm curious. I'm curious, Mr. Chair, if I could ask Rory a question.
Sure.
Rory, about 4 years ago, I represented a woman, part of a couple who were engaging in a sexual act, both consensual, on their deck. And the complainant was a neighbor across the street. They were charged with an L&L. And I don't know how they could give or get consent from the complaining witness. If I hear you correctly, you would not charge that as an L&L?
Now, under the present circumstances, that would appear to satisfy the lewdness definition, which would be prohibited conduct. It would not satisfy the lascivious element unless there was some specific showing that they were engaged in that conduct trying to excite the lust or passions of other people outside of that consensual unit.
Well, it's just one of those things that has me scratching my head here, wondering what we're getting into, because it was brought as an L&L, and I'm not going to fault the prosecutor for making that decision, but well, she's a judge now anyway, so I'm not going to worry about her at this point. So
can I just add, so I had forgotten, and Rory, thank you for the talk about the prohibited acts. And I can send you guys the prohibited acts, prohibited conduct language, because you guys just did that a few years ago after that one case. So I'll send that out.
Okay. Rebecca Turner has her hand up.
Thank you, Chair. Two more wrinkles I want to throw before the committee on this.
Appreciate that. And
I know.
I realize that many folks would prefer that no bill pass.
No, but
I understand that.
And I want to make sure the committee is aware that by linking the 2601 in the definition section of consent in section 1, not only is a problem of vagueness and issues, but what you can see in this is that right before section 3 defining consent is section 2 defining sexual conduct. And so what I want to make sure that the community understands is that by linking the term sexual conduct and consent to 2601, you're now departing from the legislature's previous definition of sexual conduct just right before and as used in that particular chapter. The other complicating factor is that lewd and lascivious is in a different chapter. And so all of these, and I understand what Attorney Tebow is saying about not having the link, but again, looking at section 3, the current section 3 relating to trial procedure and consent, there was already a link to the 2601 lewd and lascivious. Again, more reason to proceed with caution and to not incorporate a 2601 willy-nilly into it, particularly how when you read it now, this new expanded definition of consent, linking it to 2601 in the context of the sexual assault statute, and how we understand that it's involving a sexual act without consent, which now involves not just without consent involving a sexual act, but the sexual conduct. Are you proposing that the alleged physical conduct, the sexual act, is actually disconnected from the lack of consent, which could be connected to something other than a sexual act? So I want to make sure the committee understands the interplay.
We understand. I understand that what if we, Michelle, if we were to leave out the definition?
I think it's fine because as long as you're not changing 3254 where it's already referenced, and then since there is a disagreement on whether or not there should be the reference in the definition section, I think you can just take that out, and then coupling that with your directive to the Sentencing Commission to look at whether or not there should still be the reference to lewd and lascivious in 3254, I think works.
Okay.
So-
That make people more comfortable?
Yes.
Mr. Chair, are you talking about striking section 1?
No.
Oh,
Just the reference to 2601 in section 1.
Leave that out.
Okay. So it would say, now I'm confused.
Okay.
What is,
It would say, so looking at the language here, consent means the affirmative, unambiguous, and voluntary agreement to engage in a sexual act, which can be revoked at any time. And it just takes out the reference to 2601.
okay,
Reason why, again, I had just brought it up is because it's already existing law in 3254. But I don't, and you probably want to hear from prosecutors, but I don't think it does any damage here, and you can still have everything else if you just strike this reference in consent in section 1 and do your directive to Sentencing Commission, since you're not really sure whether I think what Rebecca is saying, and I get it, is that if you're unsure about whether or not you want this consent stuff to apply to L&L, don't double down now on it when you're asking the Sentencing Commission to take a look at it. Just leave it as is in 3254.
that
Okay.
makes sense to me.
Yeah, it makes sense to me.
All right.
Thank you.
So we would, okay. Next issue is totality of the circumstances, Joe. Is that where you're uncomfortable?
Yeah, and I'll tell you I really get concerned when the legislature starts to, I guess, back specific statements at the expense of any kind of factual circumstances in which not only a judge but a jury would all look at that situation and say, that's crazy. Why would we want to convict somebody of that circumstance? And that's why I think the totality of circumstances has been incorporated in our jurisdiction or jurisprudence for decades. And so to eliminate that language from this equation leaves me very concerned, especially if we have no evidence that it has actually been abused in some fashion.
I think we're going to have to vote on that individually, whether we leave it in or take it out. And Michelle has to leave for House Judiciary. Sarah Robinson has a comment. Michelle, what's your schedule for Friday?
You have me scheduled from 8:45 to 10 on the Butte bill, but other than that, I have the rest of the morning open.
Okay, so if we were to schedule a vote on this at 10:45 Friday morning, would you be able to do that? And you would have
Sure.
this amendment plus drafting whatever we need in order to have the Sentencing Commission look at L&L and how it would fit.
Sure.
So
I can get y'all
this-
something by tomorrow so everybody can look at it and.
Yeah.
that.
and dropping the reference to 2614.
Yep.
2601. So basically my amendment that I suggested with those changes. And then we can vote on totality of the circumstances and have more debate on that at 10:45 Friday. But that, we need to vote it out or vote it down, one or the other on Friday morning. So Sarah, you got, Michelle, thank you. I realize you got to leave to go to the awful place. See you soon.
Yeah.
Sarah?
I just wanted to note on the totality of the circumstances. A few particular considerations that I was thinking about. Our rape shield law right now does not prohibit introduction of, specifically introduction of what a victim was wearing. And so while that may be in some case law, that could be the totality of the circumstances that could be invited in. I think you could also argue that it might be easier to introduce evidence of prior sexual conduct and overcome the presumption against introducing that kind of material with that kind of language in. So I just wanted to speak to Senator Benning's specific concern about not necessarily having examples. I think those are the types of examples we would be concerned about with that language.
Thank you. I'll give you the final word on this, Joe, and then we're going to take a break because we need to go to, need to hear from Bryn on, we need to make decisions about H428 regarding hate crimes at 10:45.
Yeah, I appreciate that, Dick. And I want to say, first off, we all have an agreement on what should be happening with this bill. There's no reason to shoot it down in my eyes. This provision is important as a defense attorney because the two examples that Sarah just used, I have never seen a case that was successfully defended based on those allegations. And that's where I would be concerned if there was actual proof that somebody had beaten a charge of sexual assault because of something that somebody was alleged to have been wearing. The redesign of the word consent is very clear, and that would become almost irrelevant to the equation. So I'm understanding that she has a concern, but I don't want to hamstring some quirky factual circumstance that I should be able to argue in front of a jury might be rationale for suggesting that actually consent was given. And I'll leave it at that and take whatever lumps I get in the press.
It's clear that Friday morning we'll have a vote on adding or leaving it out. And we'll have a vote on the amendment as it stands right now. Obviously, if somebody wants to put the study back in or make any other changes, please get them to Michelle by tomorrow so we can take positive action on this bill on Friday morning. We're going to take a break, Peggy, until order of. We have a chat here, and I don't. Just the chat was from Michelle that she had to leave.
Chats.
All right, I want to thank all of you who have been here as witnesses to Sarah, Rory, Rebecca, and David Shearer. Appreciate it very much. And any comments you have next on Friday morning will